welcome back. So if you watched the previous step in this video series on how to submit workers' compensation claim within Queensland, you'll know that I was explaining what you need to know if work cover rejects your compensation claim. So again, if this is the case, you would have a 3-month timeline from the date of your rejection to apply to the work compensation regulator for review. This will be a completely independent review of the decision that has been made. And again, it's really crucial to note that the 3-month timeline cannot be extended, so any right to compensation or damages will be completely void if you don't take it to the regulator. Now, a side note that I want to mention is that if the workers' compensation regulator is now in your favour, work cover or your employer have a right to appeal to the Queensland Industrial Relations Commission. This would be against the decision that has been in your favour. If this happens, it's important to note that the regulator will defend that appeal on your behalf and pay for any legal representation, which is definitely a positive for the person having to go through this particular stage. And you also will be continuing to receive work cover benefits in the meantime. Now, if you've already been through the stage of submitting a workers' compensation claim and your claim has now been rejected, now suddenly the regulator rejects your review application that you've submitted and you still do not have a claim that has been accepted, the last resort is to apply to appeal against that decision made by work cover initially to Queensland's Industrial Relations Commission. Now, this is really problematic for the person injured, and within this situation, the success rate for appeals in the Industrial Relations Commission is around 2%. This is where the injured worker has appealed and represented themselves and not having engaged lawyers to run their appeal on their behalf. So this is really reflecting the legal complexity behind all of this. There is significant legal complexity and expertise that is needed to run an appeal in the Industrial Relations Commission and to be able to succeed and have a positive outcome. Unfortunately, it is near impossible for a person to represent themselves and for the average person to handle that particular task on their own. Hence the incredibly low success rate. The reason that it is so rare and almost impossible for a worker to find a lawyer who would actually be prepared to run an appeal in the Industrial Relations Commission on their behalf that is no win, no fee, is because apart from the low success rate for appeals in general, all appeals within the IRC require a significant amount of time and money in being able to prepare and actually run the appeal. If the appeal is unsuccessful, the lawyer's time and money is lost in that process, and that's why it's almost impossible to find a lawyer that is no win, no fee based regarding this particular situation. In the 2% chance that it is successful, the costs awarded against the regulator will cover no more than 10% of the worker's legal fees. Even a successful appeal guarantees them nothing in terms of recovering damages for their injury. The successful appeal would essentially result in the approval and the outcome of the acceptance of their claim, and essentially having to then go through all of the challenges and hurdles to recover damages along the way. At this point, you're actually at the starting line. You're not at the finish line. So this is also really important to take into consideration whether this is something that 2% being the success rate, if mentally you want to take yourself down this path, because again, for anybody going through and experiencing a psychological injury, your well-being is the most important thing. So with such a low success rate, you have to ask yourself that question: based on my case, based on my circumstances, based on my psychological injury and my mental well-being, is this truly worth the capacity mentally, emotionally, financially to go down? And am I going to be able to move through this particular stage? Unfortunately, this is really the end of going through and applying for workers' compensation and applying for a claim. The appeal is the last and the final resort for an injured worker. Given that this is their last resort and they haven't had their application for the compensation claim accepted at any previous stage, they can only ask around and receive legal advice about their prospects, what a lawyer will think about their case. This video is really important to know for the people who are at this particular stage, and to genuinely know what an appeal would involve and the legal complexities behind it, the capacity that will take you mentally, emotionally, financially, and why you'll find that most lawyers will usually not want to help you. As for this particular timeline, this must be within 20 business days of receiving the review which has been rejected. Again, this time frame is non-extendable. So in total, you would have 4 weeks, which the work compensation regulator has advised you that the review application has been unsuccessful, to then file the paperwork within the Queensland Industrial Relations Commission. If you don't do it within the 20 days, you're out of time, you're out of luck, and that would be the end of the process. Thank you for watching this far, and please do share with anyone that needs to see this information, and I'll see you in the next video.